Good day to you and welcome to another Paddocks Club video tutorial. Today I'm going to talk about permanent alterations to common property that is not subject to exclusive use rights. I've dealt with issues very similar to this in the past, but this thing comes up again and again. So I want to go through it and take you through the principles. The body corporate represented by the trustees has an obligation to control and manage all the common property for the benefit of all owners. That's in terms of section 36(4) of the Act. The body corporate shall, it says, subject to the provisions of this Act, be responsible for the enforcement of the rules referred to in section 35 and for the control, administration and management of the common property for the benefit of all owners. So that's the background. The way in which this comes up, as it does, as I say repeatedly, is that an owner wants to make some change. It could be the installation of a skylight, it could be the changing of a shape or size of window frames in a section owned by that owner. It could be just about anything. And in fact, on the issue of adding skylights and light tubes, there is video tutorial 64 if you want to have a look at that for a slightly narrower approach to the issue. But normally you expect that the way this thing will present to the trustees is that an owner will make an application for permission. Hopefully, if they talk to some trustee, the trustee will say, put it in writing because it can only be considered by the trustees. Now, the trustees must start off by taking the view and understanding that an owner doesn't have the right to make changes to common property. There are some things that he or she can do. They can install a locking device or gate or burglar bar, a safety device for the protection of the section, as long as the specification for that particular item has been approved by the trustees. But other than that, they're not entitled to mark, paint, drive nails, screws, make any changes, alter any or damage any part of the common property without first obtaining the written consent of the trustees. And that's in terms of prescribed conduct rule 4. Have a look at it. In looking at the application, the trustees should first ask, is this sensible? Is there a clear need? Does this owner have a good reason for wanting to do this? And secondly, will there be any negative effects on other owners? Now, one of the first things that the trustees will look at is the issue of appearance, or perhaps that the use of this changed area of common property might interfere with other people's ability to use their own common property or their sections, and that's something they may even want to talk to immediately adjacent owners about. But if they decide after the investigation that it's going to reduce other property values or negatively impact the looks of the property, then they must refuse. And they must also bear in mind that if they give permission to one owner, other owners might well want to do the same sort of thing in their particular area. And what would be the effect if they all did? They've got to look at that issue. They can't just say, oh, well, you're the first, we'll give you the right to do this thing, but realizing that other people couldn't do the same. Almost always, any change will have a maintenance effect. And the first question the trustees have to address is, will it be the body corporate who has to take over and maintain and repair this change, or will the owner and their successors entitled take responsibility? And that's not the norm with common property. So what special arrangements do we need to make sure that that does happen, if that's what we want? Do we need to impose specific conditions? If so, let's make sure that they're properly written down, that they're sensible. Perhaps we get a lawyer to check them to make sure that they will in fact stick. And is it necessary to have this area made subject to exclusive use? In both issues, the question is a rule change necessary? So these are the issues that have to be looked at. But this assumes that the owner does in fact come and ask for permission. In other cases, the way this hits the trustees is that they find that the owner has just done it. The skylight has been installed without permission or some other change has been made. And what should the trustees do? Well, the first issue is that they should make sure that the common property is regularly inspected to pick up any changes that have been made without permission. And when they find one, they should apply the same principles they would if the application was new. If they don't approve it on the basis that I've dealt with above, then they should make the owner remove it and restore the common property to its previous state. They must not also let any transfer be registered until such an issue is dealt with, because then a new person comes in who doesn't have the history, who wasn't responsible, but who now is benefiting from this thing, or perhaps saying the body corporate must maintain something which my predecessor in title installed. This doesn't mean, however, that you should wait until a transfer is in the offing before you deal with the issue. The law expects trustees to be proactive in the administration of the common property. So these inspections should be done perhaps every quarter, perhaps every half a year, perhaps every year, but on a regular basis to make sure that there are no unauthorized changes to common property. And if the owners have in fact made such changes, then the trustees must deal with them swiftly and effectively. Thank you for joining me. If we have any further questions, please can we deal with them in the discussion forum.